Hi, everybody. This is the May 2019 edition of the Third Fridays podcast.
Third Fridays, is that correct?
Yeah, not Thursday.
Fridays.
Third Fridays
Got it.
podcast.
Trademark,
Right.
TM, registered service
Right.
mark.
Put that
Christian
copyright.
Season.
I don't know. Maybe I should do a more aggressive marketing plan and take more trips around the country.
Was that possible?
Right, that's a good point. I just came back from Texas and California to do some trainings and some speaking engagements on panels to talk about the Third Fridays.
Oh, Third Friday
podcast.
Understood.
Right.
Got it.
Okay. So just to remind everyone, the Third Friday of every month is the one day where there are no board hearings across the entire state. In opposition, there are hearings on the third Thursday of every month.
True.
Right. So the podcast you want to listen to is the Third Fridays podcast because
Don't be confused.
Right.
There might be a similar sounding product out there.
Right.
But it's not the same thing.
You don't actually want to listen to a podcast where you actually have your own claims at hearings because those are more important.
That doesn't make any sense.
Right. Okay. So if you haven't heard or really seen through camera 1, 2, or 3, my guest again is Greg Lois. I can tell that you're very happy to be here.
Yeah. I don't know how I landed this choice spot, but once again, I have sent our partner John Marzola on a trip up to Buffalo to make him unavailable.
There it is.
So this is working out swimmingly for me.
Right. You figured out the way to eliminate all possible candidates and bring yourself back on the show.
Correct.
But let's
it's
talk.
Tricky. I got to figure out what day you're going to record this. Then I got to
not an easy
some
task.
Reason, I'm telling clients, hey, how about a file review? How about some on-site training? I could ship somebody up there.
Right. And process of elimination.
Mm-hmm.
You come on the show, but I think it's going to be okay. I think it's going to be okay.
I'm glad to be here.
Last episode was a furiously downloaded episode from what I hear and see on analytics, whatever that means. And we're going to continue that trend and talk about the 201 level application to our New York webinar series, which is every third Monday of the month, right? So not
Correct.
Thursday.
Right.
Monday.
Right.
Followed up by the Third Fridays podcast.
Right.
Okay, so on Monday.
Should we let everybody in on our joke?
No.
Let's let them in.
No.
Let's let them in.
Okay.
Someone tried to steal your thunder by coming out with a legal podcast that they have named Third Thursdays. They are trying to horn in on all of that equity, all of that excitement that you have developed and trick people. Right?
Yeah, don't be fooled because the Third Thursday could technically come before the Third Friday and then not feel that you don't have this loving voice coming through your speakers because
I know when I wake up on a Friday morning and I go to my podcast player and you aren't there, because mine pops up. It tells me Overcast will say there's a new podcast available. When I wake up on a Friday morning and I'm like, where is it? Where is it?
Right.
Where is it? You know?
What is they say? They say the greatest form of flattery is imitation. Correct. Or something like that.
Yeah.
But they also say the second verse is never as good as the first.
That's true. I mean, what if there was an attorney out there whose name was Sistan Keeson out there, just obviously drafting off you, just copying what you're doing.
Right. Not that much more difficult than my own name, but I get it. That is difficult, and I would be a little miffed. This is more comical to me because I know that the talent and process that's in this room is so high. I don't need to worry about that. But let's go back into the content form so that people don't decide that they're not here for something that they are.
Get
right?
Involved in a podcast drama,
a war, turf war, right? Okay, so the webinar for the New York series is on your common garden variety defenses. And we have a very established and robust and regimented intake client relations team that really takes in every file. And for the denied cases, since we know that our clients really trust us for the denied cases because our case population is, kind of more than your average defense firm when it comes to denied cases, right? We do a lot of process to make sure that our clients get the best representation. So, Greg, as the founding member of this firm, could you shed a little light on how our client relations team puts our clients' interests at heart?
I think you mentioned something which is important to note, which is, look, we're a workers' comp defense firm, right? So we're not seeing the run-of-the-mill, the average case.
Right.
85% of workers' compensation cases, claimant gets injured, loses some time from work, goes right back to work within a couple of weeks, and they're on with their life. We only see here like the 15% of cases that have fights. Statistically, in New York State, for the last year we have statistics, about 9% of cases are controverted, denied, disputed, however you want to call it. Okay, so those are the denials. In our office, our case population is more than a third denied, right? So when employers or carriers are deciding, hey, this is one I want to challenge, they're thinking, where do I send it and how do I send it? And so I think we identified early on that this is like a real important moment for us to step right up and step up quickly. Our system is to communicate with the client immediately, to gather whatever investigatory materials they have, and that could be anything from just like an accident report or the statement of a supervisor, manager, anything.
Right.
And we're giving them advice on exactly what defenses should be raised in their first report of injury, because that's the form that gets filed with the state, and that's where you would establish that you are denying, disputing, or controverting this case in New York State. Now, interestingly, other states that we practice in other jurisdictions, we would be filing that initial statement saying, hey, we're denying this case on behalf of this employer or carrier. New York's a little different in that it requires the carrier or third-party administrator or employer to actually file that first report of injury and then advise all parties, hey, we're disputing, denying, or controverting this matter. So, our intake team, the way that works is that they would provide that information, meaning, hey, here's the specific legal offenses we think are appropriate and can be sustained in this workers' comp case. And they're over there triaging matters and then immediately telling the client what to put into their paperwork. So, it really begins, to use sort of a Christian CSON term, on day one.
You kind of took the words out of my mouth, because I was really going to segue into how the process reflects that mantra, right? Defend from day one. So that's one on the counter, Ms. Producer, for the amount of times that I've said it.
Well, I said one too. So
okay, two.
That's
two.
Yeah.
Two. Do you think they say defend from day zero?
Who knows what they say? I haven't listened to it yet. I am very interested.
Well, no one listens to it.
Oh,
okay. All right.
Internet drama.
All right. The Monday webinar is going to go over some common legal defenses, and I think it's kind of important to stress that the 201 level podcast is really, it came together because it's kind of the process that our own attorneys really go through when we talk shop, when we train each other, when we put our heads together to put together a strategy. It's why don't we share this with our clients, because it helps them in their process, right? So watch out for that on the webinar, everybody, to take note of the common legal defenses that you will have for your claims. But I wanted to specifically point out how the expedited hearing process really puts that into motion and stresses the importance of defend from day one, right? So let's imagine that on Friday, May 17th, the third Friday of the month, there's a work accident, right? And this claimant reports the accident on the same day and goes to a hospital or urgent care on that day, May 17th. Now, if we take the 1810 rule specifically to heart, the latest you can file the FROI 00 is June 4th. Now, in order to get all that information together, you actually have to do the investigation in those 18 days. So my idea is to not do the investigation just to get the report out, but maybe give yourself a chance to get your ducks in a row for a compensability determination as well, right? So like you mentioned, the accident reports, the witness statements, the medical canvas, the ISO prior claims search, anything that will allow you to make that determination while the history of the accident is fresh, right? Now, when you file the FROI, right, that notice of indexing can pop up at any time. There's no set guideline for when the board's going to index it against you and start that 25-day timeline.
Yeah, it's hard to predict. It seems like from the filing of the FROI, that could trigger an indexing on its own.
Right.
It might not.
Or the medical report might come in. A medical report
coming in
C3,
could trigger it. Sure.
An RFA-1 if the claimant has an attorney, or maybe even if they're unrepresented, their own RFA. So that kind of is this like cloud hanging over the expedited timeline, because as soon as you get the SROI 04, or if you decide to deny it immediately with the FROI 04, that plus the medical record in conjunction will set a pre-hearing conference within 30 days. And that's by regulation, right? That pre-hearing notice will come out so that the pre-hearing conference is 30 days after the receipt of the board of both of those things. And at that point, now we're like in a place where we have to really ramp it up if we haven't done it already, right? So that's your pre-hearing conference statement. That's your witnesses and any documents that you plan to use at trial, and maybe even IME, because that has to be planned for to be in place for trial. So I was thinking that if all that process took place, right, where you have the May 17th accident, the FROI on June 4th, the pre-hearing conference 30 days after the denial and the medical, your pre-hearing conference for a mid-May accident could take place as early as late July.
Yeah.
Where
Correct.
You have to be ready to state your case and have all your evidence, all your witnesses, and then a trial in late August. That is a very, very strict timeline. When I spoke at this legal panel in Texas earlier this week, there was a Florida attorney there who said that their timeline for litigated cases in dispute is 6 months.
Right.
So, and they actually use the word fast track or expedited too. And I was like, I would love to have that timeline because ours is more expedited.
Our rocket docket's 3 times as fast. And so entertainingly, when you do the math, case gets indexed statistically 28 days to pre-hearing conference.
Right.
And then 55 days from there to judge's decision. Right. So that is a really short period of time. And, it's hard. For an employer to marshal witnesses, complete an investigation. Certainly, if the person has pre-existing, I could be sending out HIPAA releases to my adversary. Do they ever return them? No. Am I subpoenaing doctors for prior medicals to prove that this accident did not cause these injuries? And by the way, then the doctor has to reply to my subpoena, and all within 55 days. It's just never really going to happen that way, that cleanly, and it's really puts quite a burden on the employer and carrier to try to disprove a case in such a short period of time.
Right, and I think the common perception is that a bigger employer, your Fortune top 40 companies of the world have more access to these resources and can do this properly, but it's not always possible because those companies actually have multiple locations. So many hands in the cookie jar to really, make this more of a problem.
Sure.
So across the board, whether you're a company of 2 or a company of 2,000, it's not easy.
No.
And so starting the process early is something that we have recommended because it puts you in place, right? It allows you to assert a good defense. And we know that, if 8% of all cases across New York are denied, and then an even smaller percentage of those are actually upheld, we want to make sure that every single duck is in a row to allow us that opportunity to get that disallowance at trial.
And you know what, so much of this too, I think your message on defending early, really putting your effort into the very beginning of the case, I think it's a very good and timely message. 10 years ago, the maximum rate was $400 right?
Right.
I mean, we were talking about literally a different world. 10 years later, maximum rate's over $900 a week, and it's going to go up to $930 in July, right? I mean, it's going up and up and up.
Facts.
These
Great
cases
info.
Are, every case that you had has doubled, more than doubled,
right,
in exposure, in cost, in value, right? All of those things have all gone up. And so the way we used to handle cases, 15, 20 years ago, where, hey, they'll file things, they'll go to the doctor, nobody's following up, they're kind of breezing through the system. I think some of that was born of the mindset of like, well, look, they've got their Section 21 presumptions. We're going to lose anyway.
If you lose, it's not that bad.
And if I lose, it's not that bad, right? I mean, people used to say, well, in New York, the medical's out of control, but hey, the indemnity rates are real low, right? $400 max rate is like nothing. Now that's all turned on its head. You know, New York is now pegging benefit to the state average weekly wage, which is just going up and up and up every year, right?
That is, that's an extremely important point that a lot of people don't really take into consideration because, this computation of the average weekly wage of a sample size of the state, we don't know how that process
we know that
happens,
it's gained, right? So, I mean, the way they do it is they don't count people who are part-time or are leaving the workforce. You know, they do all sorts of things to keep making sure that state average weekly wage goes up every single year. The only exception in modern history is New Jersey in 2008 and 2009. Their average weekly wage calculation went down a couple bucks. And that was just because the state was whacked so bad in the financial crisis. They actually had so much structural wage depression in that state. But, historically in New York, we've seen 10 years of it going up every single year, regardless of all of the dire statements that are made all the time about how, the economy is growing, but real wages aren't growing, right? People keep saying it doesn't keep up with inflation, all these things. So, again, I'm off my soapbox now, but...
that was an incredible soapbox, by the way. I think you're upping your candidacy for more future appearances. Yeah. That was great.
But the mindset, though, of and we see this all the time of how people approach the New York cases in the past, just sort of, it's a low exposure state, and we got to really break up or shake that mindset up into this more modern approach, which is, hey, look, some of these cases, some percentage of them are going to be defensible. We should be defending them. We should be controverting them. We can do it.
That's true. And so it kind of leads me to my next question, I guess. So I was trying to think of balancing the interest of getting us involved for a defend from day one strategy with also, a client, self-insured or a carrier or TPA's desire to keep costs low, right? Mm-hmm. So when would be, and I'm okay if we disagree on this because I think it's up for debate, when do you think would be the optimal time for a client to say, okay, Lois, I need you now to help me on this denial? Like, at what point is the optimal time?
I would say one of the things that you've done, and I'm gonna toot your horn here, which is go to clients in advance, right, before pre-accident, and say, hey, I will review or audit your injury reporting procedures. I will go through how you're collecting information. What are the contacts? Who's on that list? A thing our partner Tashia does all the time because she's defending these big construction projects is go to the safety meetings and make sure that there's a very clear ladder of how things escalate through the project or through the company. And really starting to think about, hey, how when someone gets injured here in this workplace, how does it get reported? Who's in that chain? Who can make decisions? Who then tells the carrier first? All that pre-stuff is a really great place to start. So it's. I think your question is like, hey, when do you call your attorneys? And really, it should be like, if you're a big company with a lot of risk, it should be like well before you actually have any loss.
Right.
And putting that stuff in place. I mean, one thing that I know you've done for our clients is audit their initial, investigation materials.
Sure.
Right. And just say, hey, look, leave this out or put this in, or this would be great to have. So all of that stuff, I think, and that's a project I know you've worked on with clients just off the cuff. In other words, it's like an added benefit or an added service that you provide to your client because, hey, you're here to help out. It also helps you, by the way, as the attorney, get to know a lot more about your client's business so you can better serve them. But I think that's really when you're talking about it, like really there should be a plan in place well before that first loss comes in on that job site. Tashia is doing that on these construction projects because they're putting together the risk management team a year in advance of breaking ground on the project.
Right, which makes sense. Got to have it in place for bids and contractors and all that stuff to make sure that there is a protocol because those are such high level cases that there needs to be a structure.
High exposure.
Right.
Yeah.
For everybody to follow.
Mm-hmm.
Right.
Mm-hmm.
Yes, call Tashia is definitely on that list.
And then I would say, from our experience, I've only been at this for 18 years, but I have clients that call me the day of a loss.
Right.
Catastrophic. I mean, I've gotten phone calls or people are at the work sites and you hear screaming and yelling and machines in the background.
Yeah.
Guy got his leg ripped off and, hey, what should we do? All the way to, 2 years ago this accident happened.
Yeah,
Can I deny it
right.
now? And you just go, what have you been doing? So, from the perspective of when do they engage us? It's all over the place. It's all over when do they first say, hey, wait a second. Is this thing compensable, or is this really work related or not? It's all over the place.
Yeah, I think that's why the debate. I think that's why the debate kind of ranges on, because there's the competing interests are really there to make sure that the claim is really put first, right? Like the opening and the closing of that claim is put first. My thoughts were, if you don't have that procedure set up that Tashi is doing with construction claims and the audits that I'm doing of our clients, if that EC84 comes out and you don't have us on the roster, that's the time to pick up the phone. I feel like that's the last moment where you say, like, well, because now I need to put in denial codes. I need to make sure that I marshal the right witnesses. And, even if we were to do it for our clients, we'd still need help from employers then too. So it's really putting all the right heads in the room so that the right decisions are made and no deadlines are missed, so that the best denial is put forth. And that's the one that you win. You win the denials where all the ducks are in the row.
Sure. I mean, it's one of the things. Look, we can't win every case, right? But I want to win the ones I can.
Right.
And I do think that the ones that we should win and can win are the ones where, hey, we early identified this is a case we need to controvert. We've early started to look into the claimant's background and start to say, wait a second, this is the fourth left knee claim this person has had in 6 years. Okay, something's fishy here. We see the same doctors, and you subpoena the records, and you're putting that case together. And that work should be done as early as possible because, once the time starts running, it's running against us. The Section 21 presumptions in New York essentially are the person claims he got injured at work.
He got injured at work.
Compensable. And it's really up to us to overcome those presumptions. And when you're in a situation where really every presumption is running against you, you really got to marshal everything together as soon as you can. And that's, just such basic things. We have video that shows the person doesn't get hurt. Well, let's make sure this client doesn't lose the video of their own workplace, because we've had crazy things happen where they've said, look, I got a video that shows the guy leaves our work site at the end of the day and he was fine. And by the time we actually get to a hearing 90 days later, whoops, we lost the video. We've lost the recording.
Right, because it gets discarded or replaced.
Or just nobody put the hold this flag on it, or somebody's desk changed or whatever. And, those are the things where you just say, well, look, this needs to be put together a lot better earlier in the case. And, I think most of the work in a case should be done before it goes to that first hearing. We really should be well down the road to figuring out what's the end point of this matter.
Right. No surprises, right? Putting everybody in a position to expect a good outcome. When you go to trial and there's kind of, this question of compensability or a decision from the judge, you're right. The Section 21 presumption really puts, the burden on us to really, really make sure that this isn't one that shouldn't be compensating the claimant.
Yeah, and also it runs the other way too. I mean, we've had cases where we initially said, "Oh, this is a denial case. This can't be compensable." Right.
And then you investigate.
A couple days later, we've now looked into it. We talked to a few people, and you go, "Wait a second, you should accept this case." And here's the other side of accepting the case: when you deny the case, you lose control of medical information. Right? They're still going to be out there getting medical, and they're going to be doing whatever they're doing. But they're not going to be providing it to you. It's not going to be feeding back to you in the normal way. So sometimes we'll say, like, hey, maybe this is one where, like, accept it without prejudice, or just accept it, because at least we'll stay on top of the meds. We'll at least know what's happening on that side of the case.
That's a great point.
Which becomes the driver.
One of the things I spoke to on the panel about too was, like, when you're making that decision to deny, you're drawing a line in the sand. You're on one side and the employee's on the other. So when you make that decision, if it doesn't turn out your way, how likely is it that you're going to be friends with this person.
Yeah, the cooperation goes away at
right.
that moment.
Like he's not going to come back to work for you, or not. That's not fair. He's less likely to come back to work for you, and I think that's kind of the biggest problems in the system, where there's a disconnect, and it becomes an administrative law becomes too litigious, right? So like making the right decisions at the right time actually is in the best interests of everybody.
Well, I mean, that's the insane thing is workers' compensation court was designed as a diversionary court. This is to keep people
to prevent from suing their employers in civil court. Right,
and it has become a situation where it's so bad. The outcomes are so skewed and so bad, and the limitation on discovery and the regular due process limitations are so bad. In many states, employers are saying, "I want to opt out of workers' comp. Come sue me in big boy court."
Right.
I'd rather face you in big boy court with actual rules than under these circumstances, where I can't argue anything. No comparative negligence, no contributory negligence.
Right.
And by the way, extremely limited discovery. And in New York, we're talking today about the expedited hearing calendar. We still call it the rocket docket. From date of loss to hearing outcome, it might be 90 days, it might be 100 days. It's really, really, really short. And that whole idea of, well, there's a balance here. You really want to get this person justice. Really, if they really are legitimately injured and harmed, we want to get them care. We want to get them justice. But there has to be a balance here with the employer's right to actually defend themselves.
Right.
It's it's not really due process to say, hey, great, you guys have the right to defend yourself and bring up any real legitimate substantive defenses, but you have 40 days to get all that done, or 55 days to get all, some incredibly, short period of time to put all of our defenses in. It stretches the credibility of the system.
Yeah, that reinforces, the pre-procedures and the planning that we put in place for our clients, and we've seen some good outcomes because of that, right? Mm-hmm. Faster claim closures, more disallowances in court, more appeals successful before the board panel, and it's definitely the right way to go. I think that you mentioned employers kind of opting out of workers' comp to almost allow the civil suit to proceed. And that actually makes this seat almost feel like a soapbox for me now, because I always said, too, it's like once it gets so bad, there's a new bill like every 2 years that makes it worse for employers in New York. Like, could it be so bad that, an employer says, I'm not going to do business in New York?
Sure.
Because
look at Rochester and Buffalo and everything north of New York City. I mean, every industry, a lot of industries moved out, and they're all down in North Carolina and South Carolina, and places that have much less plaintiff-favorable litigation climates. Let's put it that way.
Right, and then there's going to be this. There's going to be an upstart politician coming up. I'm not naming anyone specifically, but no, you wouldn't lose me.
Yeah.
No, I'm just talking about a hypothetical person that's going to look at the landscape and say, we're losing these entrants into our economy, and that's going to create jobs for people, because the workers' compensation system is so rife with penalties against the employer and the rocket docket not allowing proper investigation. So I do think that time is coming if it gets so bad. So everybody that's listening and thinking that your New York claims are so undefendable, I do see a silver lining the worse it gets, right? Because it can't – sometimes it doesn't seem like it can get worse, and then it does.
Are we talking about DFD1? Okay, that was the fourth reference.
Yeah, I got kind of
Christian Seeson.
That might have been.
Is this the? Are we? This is an announcement? Is this
like
a campaign
coming out on a platform right now, like on this podcast?
Going with this.
That would be pretty gutsy for me to just my current employer in the room to kind of sow the seeds for this political.
I'd vote for you. You know what? It's because you're passionate. You've got some passion around the topic, so I feel like it's very compelling. Let's think this through. I don't know. Is it too narrow of an issue to unite, the general voting public?
Yes.
Yeah.
Yes. Yes. No, I thank you for the endorsement. Obviously, it's not the only thing I'm passionate about, as everyone else will attest to me being incessantly annoying to them in my personal life. But I think that the idea behind it makes sense for what we do today, right? You're planning for the process to occur smoothly, because in reality, it's not going to be smooth. It's going to be very rough. It's going to be very difficult, and you're going to be faced at some point in that 90-day rocket docket of, oh my Lord, like I don't know what I'm doing here because of all the timelines. So setting it up, even before day one, is actually going to get you to the right place. I think that's a great place to end the Third Fridays podcast. What do you think, Greg?
So happy to be here with you. Thanks for having me back.
Yeah. So everybody, I want to thank you guys for listening. If you take anything out of this, rewind the podcast to the riff discussion between me and Greg about how the expedited calendar can really, really make sense for you to defend from day one and do those pre-action policies before the accident happens to set you up, right? We talked about a May 17th accident resulting in a late August trial. That is our reality. So think about how that can influence your processes, your procedures, and as the host of the Third Fridays podcast, I'm reminding you to defend from day one.